welcome to the deep dive. We cut through the noise, take those really dense sources, legal rulings, complex research, and pull out the key insights so you walk away knowing what actually matters. Today, we're tackling a pretty significant topic, medical professional misconduct, right here in New York State. We're digging into a very recent case from the New York Appellate Division, decided just October 16, 2025. It's a matter of Kevin Weiner versus the New York State Board for Professional Medical Conduct. Now, if you're working in this area, you might glance at this and think, okay, a doctor disciplined for bad records, maybe some negligence, standard stuff. But the real takeaway, the thing that makes this case interesting, is procedural. It's all about process. The question is, how much warning does the state really have to give a doctor before they file misconduct charges? And, maybe more importantly, what happens when the doctor holds back records, and how far back can the state then reach? This case really draws some important lines in the sand for the disciplinary process.
So our mission today is to unpack Public Health Law Section 230. We want to understand why Dr. Weiner's suspension, it was a stayed 2-year suspension, was ultimately upheld, even though his big argument was that the state blindsided him on some of the older allegations, ones not specifically laid out in that first interview notice.
Right. And to understand that, you really have to start with the law itself. We're talking Public Health Law Section 230. That's the statute that sets up the whole framework for how the Office of Professional Medical Conduct, OPMC, investigates and handles these misconduct cases. And there's a key piece in there, a legal term called a condition precedent. What that means, essentially, is that before OPMC can formally send a case to a hearing committee, the law says they have to offer the doctor being investigated a chance for an interview.
An interview, like a chance to explain their side.
Exactly. It's an opportunity for the professional to provide context, explanation, whatever, about the issues the OPMC is looking into at that point.
Okay, so it's like a mandatory heads up. OPMC can't just, drop charges out of nowhere. They have to offer this interview first. But crucially, that heads up, that notice for the interview, it has to contain specific information, right? It's not just a casual letter.
That's exactly right. Public Health Law Section 230, subsection 10, lays it out. The written notice has to hit 5 key points. It needs to describe the conduct they're looking at, identify the issues they've flagged so far, give the time frame involved, name the specific patients, and tell the doctor they have the right to bring a lawyer and have a stenographer present.
Okay, 5 points. Description, issues, time frame, patients, right to counsel.
Yep. The idea is fairness, but also efficiency. The doctor needs to know generally what they're walking into, but OPMC doesn't have to have every single detail nailed down perfectly in that initial notice.
Got it. So let's apply this to the Weiner case. How did it start?
It kicked off way back in 2015. There was an anonymous complaint. The allegation was pretty serious, that Dr. Weiner, who is a licensed physician, might be overprescribing opioids or maybe even selling prescriptions.
Okay, so a serious allegation. OPMC starts investigating. They ask for records.
Correct. They requested medical records for 10 specific patients named in connection with the complaint. So Dr. Weiner knew from pretty early on that opioid prescribing was the focus for these patients.
And then the formal interview process starts.
It took a while. The first official interview offer didn't come until November 2019. That's 4 years after the complaint. By then, OPMC had looked at whatever records they'd received. The notice listed those original 10 patients, plus one more involved in a separate malpractice claim, so 11 patients total.
And what about the issues part of the notice? Was it specific?
Well, this is key. The notice described the topics pretty broadly. It included things like, and this is a quote, any and all care and treatment, diagnoses, and prescribing patterns.
Ah, so diagnoses and prescribing patterns. That's broad language.
Very broad. And that supports the later court finding that notice only needs to cover the broader issues. It doesn't have to list every single potential charge.
Okay, so the interview happens in December 2019. What came out of that?
The report from that interview is really important here. It didn't just cover the prescribing issues. It specifically noted and documented that there were extensive missing records.
So right from that first formal interaction, the state is flagging a record-keeping problem. They put it on paper.
Precisely. After that interview, Dr. Weiner did provide some more records, but they were mostly more recent ones, not the older files.
Okay, so he gives them some more stuff. What does OPMC do then?
They actually tried to offer him another interview. This was in May 2020. The idea was, okay, you've given us some newer records. Let's expand the time frame for discussion to cover those too. Let's give you another chance to explain.
And did he take that second chance?
No, he declined the second interview offer.
He declined it. Okay.
Yeah.
That decision probably didn't help him later on.
It certainly became a factor in the court's analysis about whether he'd had enough notice and opportunity.
So, quick recap. Anonymous complaint. OPMC asks for records, offers an interview covering broad topics like prescribing and diagnosis for named patients, flags missing records in that interview, offers a second interview which is declined, and all along, key older records are still missing.
That's the setup. After he declined the second interview, OPMC moved forward and filed formal charges.
Right. Let's unpack those charges. So OPMC files a statement of charges. How many specifications are we talking about initially?
Initially, there were 16 specifications of misconduct.
16. And what kind of time frame did they cover?
Generally, the initial charges focused on the period from 2013 to 2017.
Okay, 2013 to 2017. And the substance. What were the allegations?
They were serious. Things like negligence, incompetence, doing unwarranted tests or treatments, failure to maintain adequate records.
Standard categories in these cases, unfortunately.
Right. But crucially for this case, a core allegation, maybe the core allegation, was the failure to properly render a diagnosis before starting treatment with prescription meds, specifically opioids, given the initial complaint.
Failure to diagnose before prescribing. Got it. Okay, so charges filed, hearing is scheduled. Then what happens?
Then we get to the real twist in the story. We jump forward to September 2022. This is literally right before the disciplinary hearing is set to begin, 3 years after that first interview offer.
Okay, the eve of the hearing.
And at that 11th hour, Dr. Weiner submits thousands, literally thousands of pages of medical records.
Wait, seriously, thousands of pages.
Right.
Right before the hearing.
Thousands. These were records OPMC had likely been seeking, or at least records relevant to the patients, dating back much further, records they hadn't seen before.
Wow, that's a bold move. What does the administrative law judge, the ALJ, do with this massive data dump?
The ALJ makes two really critical decisions here. First, they allow these late records into evidence.
Okay, they let him in. What's the second decision?
This is the big one. Over the objection from the OPMC's Bureau of Professional Medical Conduct, the ALJ grants the Bureau permission to amend the charges based on this new evidence.
Amend the charges, based on records the doctor just submitted.
Exactly. And that amendment significantly changed the landscape.
How so? Did the number of charges go up?
It did. From 16 specifications up to 20. A footnote mentions one incompetence charge was split into 5, but the total number increased. But the really dramatic change was the time frame.
Ah, because the new records went further back.
Much further back. The state now had documentation provided by Dr. Weiner himself showing treatment for these patients going back as far as 2007.
2007. That's 6 years earlier than the original 2013 starting point in the charges.
Correct. So the treatment time frame under scrutiny just exploded backwards.
Did the core allegation change, though?
No, that stayed central, the failure to properly diagnose before treatment. But now, the state could argue that this failure was evident way back in 2007, based on the records the doctor himself had just handed over, records they couldn't previously use to make that specific time-based claim.
So the failure wasn't new, but the evidence for it reaching back to 2007 was.
Precisely.
And the hearing goes forward on these amended charges.
Yes, a 9-day hearing followed, and the outcome. The hearing committee sustained 16 of those 20 amended specifications.
16 sustained.
And the penalty.
A stayed 2-year suspension of his medical license, meaning he could likely keep practicing under conditions, but the suspension was officially on his record.
Okay, so that leads directly to the appeal, the Article 70 proceeding we mentioned at the start. He challenged this outcome.
He did, and his argument on appeal was purely procedural. He didn't really contest the findings of misconduct on the merits in the appeal. His entire case boiled down to this. He argued that the original interview notices back in 2019 and 2020 only mentioned timeframes like 2013 onward. They never mentioned 2007 to 2013. And since, he argued, his initial diagnosis would have happened back then, OPMC failed to properly notify him of all the issues and timeframes under investigation, violating that public health law section 230 notice requirement. Okay, hold on. That actually sounds like a reasonable point on the surface, doesn't it? If the notice says, we're looking at 2013 forward, and then they nail you for stuff in 2008 based on records you just gave them, how is that fair notice? Didn't the state kind of trap him, even if unintentionally?
That's the absolute heart of the legal question the appellate division had to grapple with. And their answer really highlights how professional discipline procedure differs from, say, criminal law due process. The court pushed back hard against his argument with a couple of key points.
Okay, what was the first counter-argument?
First, they zeroed in on the nature of the main misconduct, the failure to diagnose properly before prescribing. The hearing committee, and the court agreed, didn't see this as a one-time mistake back in 2007. They viewed it as an ongoing failure. a continuing pattern of deficient practice that started early and persisted right through the treatment period, well into the 2013-2017 timeframe that was initially noticed.
Ah. So because the type of failure was ongoing, the notice about the issue itself, faulty diagnosis prescribing, was sufficient, even if the start date later got pushed back based on new evidence.
Exactly. It wasn't like they suddenly accused him of a totally different kind of misconduct in 2007. It was the same fundamental problem, just with evidence showing it started earlier than they first specified.
That distinction, ongoing failure versus a single past act, seems critical legally.
It is, and the court didn't just invent this idea. They pointed to existing case law, like a 1997 case called Matter of Gupta. They basically reiterated that the whole point of adding that mandatory interview requirement to the public health law wasn't primarily to give doctors massive new due process rights.
Okay, so what was the point then?
The legislative intent, according to Gupta and other cases, was, quote, to improve and expedite the efficiency of the disciplinary process. Efficiency.
Efficiency, not expanded rights. That's a fundamental difference in perspective.
Huge difference. And because the goal is efficiency, the court reasoned, the interview notice only needs to cover the broader issues of the charges and the patients involved. It does not need to spell out every single specific factual charge or precise date range that might eventually come up, especially if the core issue was already flagged.
So the court looked at the original notice and said it was good enough.
Pretty much. They said Dr. Weiner was on notice about the broader issues, the opioid prescribing, the specific patients involved, and crucially, that first interview report explicitly mentioned the lack of preliminary diagnostic information, like chief complaints, physical exams, patient histories. So the issue of inadequate diagnostic workup was flagged early, even if the 2007 date wasn't.
So the state's position, which the court accepted, was basically, we told you we were looking into your diagnoses and record keeping for these patients. That's what we did. The fact that you later gave us records showing the problem started in 2007 doesn't mean our initial notice was defective.
That captures it perfectly, which then leads to his other argument.
There was another one.
Yeah, he also argued that, okay, even if the first notices were okay at the time, once he submitted all those thousands of pages and the charges were amended to include 2007-2013, he should have been given a third interview opportunity. Or that the whole investigation phase should have been reopened.
He wanted another bite at the apple, procedurally speaking, after the amendment.
Right. He claimed he couldn't properly respond to the amended charges covering the earlier period without another formal interview.
And how did the court handle that? Did they buy it?
Not at all. The court was quite firm on this. They stated there was absolutely no requirement in the statute for OPMC to reopen the investigation or offer another interview, just because the doctor made what the court called novel hearing disclosures.
Novel hearing disclosures. That's a polite way of saying dumping thousands of pages on us at the last minute.
You could read it that way. The court essentially said the amendment was allowed because the petitioner himself provided the records that necessitated it right on the hearing date. And since the core issue, failure to diagnose, remained the same, he was considered adequately on notice of the nature of the misconduct being investigated, even with the expanded timeline.
So no third interview needed. The process stood as it was.
Correct. The appellate division confirmed the hearing committee's determination, dismissed Dr. Weiner's petition, and upheld the findings and the state's suspension.
Okay, so let's boil this down. What's the big takeaway here for, anyone navigating these kinds of professional conduct waters in New York? It seems this case really hammers home that the pre-charge OPMC interview is about the big picture, right? It's about the general issues and the patients, not a detailed roadmap of every single allegation or date the state might eventually pursue, especially if the alleged misconduct, like poor record keeping or failure to diagnose, can be framed as an ongoing problem.
That's the primary lesson on the notice requirement, absolutely. OPMC needs to tell you the subject matter, but not necessarily every chapter and verse they might write later. But there's a second, equally important takeaway here, I think, more on the practical strategy side.
Which is?
It's about disclosure. Dr. Weiner's choice to wait until the eve of the hearing to submit thousands of pages of older records was frankly a strategic disaster for him. It directly handed the state the evidence they needed to expand the charges back to 2007. It shows how critical, timely, and complete cooperation is. Delaying or hiding records can backfire spectacularly. The state didn't really overreach here. The doctor arguably enabled them to reach further back by his own actions.
That's a really stark lesson in regulatory risk. Your own delay can create more exposure. Okay, so here's a final thought for you, something to consider as we wrap up. If the main purpose of that initial interview law is really about expediting the process, making it more efficient, how does that square with the future? Think about medical records becoming increasingly digital, dynamic, maybe even involving complex data trails from electronic health records or prescribing databases. How might the definition of broader issues evolve? If OPMC can access more data proactively, does that shift the burden? How much investigation does OPMC need to do before that first interview versus the physician's fundamental duty to comply fully and honestly from day one is something to watch. Thanks for joining us for this deep dive into New York professional conduct law and the Weiner case. We'll see you next time.